112-844, State of Kansas v. James Kinder.
May it please the Court, Sam Shire of the Kansas Appellate Defender Office appearing on behalf of the defendant appellant, James Kinder. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. To briefly state the facts for the audience, in 2013, the state charged Mr. Kinder with a severity level 8 felony. In the summer of 2014, Mr. Kinder pled no contest to that offense. Mr. Kinder was sentenced in the fall of 2014. The district court imposed a 9-month prison sentence. The duration of that sentence was largely in part because Mr. Kinder had no prior criminal history. Prior to sentencing, Mr. Kinder had spent approximately 1 year in jail awaiting disposition of his case. So he had already served his prison sentence at the time of sentencing. For that reason, Mr. Kinder asked the district court simply to impose the prison sentence. The district court declined to do that and instead imposed an 18-month term of probation. Mr. Kinder appealed the sentencing orders of the district court. On appeal, the Court of Appeals determined that it lacked jurisdiction to consider the merits of Mr. Kinder's appeal. Mr. Kinder petitioned, this court granted that petition, and that is why we are where we are today. Moving on to the legal issues presented by this appeal, I'd like to start with the statutory presumptive sentence issue. And it's our position that the Court of Appeals erred by ruling that Mr. Kinder was appealing from a presumptive sentence. And the reason for that is a presumptive sentence has a very specific statutory definition, which is the sentence provided in a grid block for an offender classified in that grid block. If this court is to look at the KSGA sentencing grids, they prescribe 3 numbers that permit for a range of prison sentences. They do not dictate the durational aspects of probation sentences. KSGA grid blocks are shaded as presumptive prison, presumptive probation, or border boxes. However, it is not the case that just because a defendant is situated in a presumptive probation grid box, that he or she is actually presumptive probation. There are a number of special sentencing rules which make defendants presumptive prison, even if they are located in a presumptive probation grid box. And I think if this court looks at the language used in the KSGA, particularly in 216804, subsection F of that statute actually distinguishes, in my view, between presumptive sentences and presumptive dispositions. And presumptive dispositions are not entirely controlled by KSGA grid blocks.
Mr. Shire, I just want to make sure I'm clear on the beginning of that argument. You said that just because somebody lands in a presumptive probation grid box, there are enough special sentencing rules that take them out of presumptive probation that you can't say they're subject to a presumptive sentence, right?
That's correct.
Okay. Did any one of those special rules actually apply to this defendant?
No, they did not, Your Honor.
Okay, thanks.
So his presumptive disposition was probation.
Actually, let me just clarify something. It is kind of the opposite. If a defendant or a person lands in the presumptive probation range on the grid box, it's really an exception to impose the prison sentence. It's not the other way around, isn't it? I mean, you have to show that maybe he did this when he was on bond for another case, then something like that. That's when the presumptive sentence or this presumptive prison sentence would come into effect. It's presumed probation unless there's an exception, rather than it's presumed that an exception applies, and then if you show it doesn't, then he gets probation. You see the difference?
I do think I get where the...
Go ahead.
Yeah, and my argument would be that there's a distinction between presumptive disposition and presumptive sentence. And presumptive sentence is just what is recommended within the grid box, which are just prison
And
sentences.
here's my problem here. Could the court imposed a prison sentence here? He served the maximum time on the grid box, right? It was the aggravated was 9 months.
Yes.
Served that time. There was no prison time that could be imposed, is there?
Well, yeah, yes, the prison time,
I mean, it could be imposed, but it was already served.
it was
He's
already
done it.
served.
Yeah, I mean, there's nothing in addition that could have happened at sentencing that could have been imposed in terms of prison time.
No.
I have another question, counsel. We just had that little back and forth where you said that none of those special rules applied. So as of showing up, he's sitting in the presumptive probation box, right? It would take a departure to get him out of that box, wouldn't it?
Well, no, Your Honor. And I think that
Okay.
cuts to our second issue that we raised in the
Okay,
petition.
I don't mean to rush you if you've got something else to say on your first segment of argument, but
I think I covered my presumptive sentence
Okay.
argument.
Can I just ask a question to make sure I understand? So what you're saying is that all that portion of the statute is talking about is the number of months.
Yes.
I mean, and that number would be imposed even in a probation case.
Yes. So Mr. Kinder could not in this case say that the district court erred by imposing a 9-month sentence because that's a presumptive prison sentence. That's a presumptive sentence. The only thing he can appeal is the district court's imposition of probation, which is what we did challenge on appeal in this particular
And
case.
the way you get around our typical definition of what a sentence is through that subsection F language, where you think in this particular circumstance they draw a distinction between what we would normally say a sentence is you were here for the last argument, I'm going to use my bundle of sticks again, the whole bundle of all those things that go into a sentence, which would be the disposition as well as the sentence.
Right, and that's correct. And the other thing I would note is that this court has traditionally defined probation as not a sentence, but as suspension of a sentence. That's language from Carr. And I think that's
And
sort of...
we go back before this, it's pre-guidelines, but we've said that you have to impose the prison term, which is the judgment, and then probation is an act of grace to allow you not to serve. Now, granted, we've had the guidelines and we've, I think, fuzzied that language after that, but I think the thing here where we may be getting hung up and where I disagree with the panel's determination that this is in fact a request for a departure. He's not asking for a departure, he's asking for the judgment part of the sentence to be fulfilled. He's asking for credit for time served. Yeah. He's not asking for a departure. He's asking for credit for time served, and that would effectively fulfill the judgment, the prison judgment terms. And how can you be have an act of grace to put you on probation instead of serving a term that's already been fulfilled? I mean, that's your argument, it seems to me. Rather, if we start talking about
I think
Uh,
maybe
this-
can I word that a little? How can you
Okay.
have an act of grace to put you on probation to avoid service of a sentence you've already served?
exactly.
Well, let's
I
go,
heard you.
putting that aside, let's go back to the language of 6803. You referred us to subsection F.
Yes, sure. Or 216804.
I'm sorry.
Perhaps that led to a miscommunication. Maybe I misstated that.
Well, let's look at subsection H, which defines the dispositional line.
Yes.
Okay, and it says grid blocks in which the presumptive sentence is non-imprisonment. And subsection O defines non-imprisonment as probation. So the KSGA from this language appears to say probation is included in a presumptive sentence. Can you address that?
Well, Your Honor, I think perhaps there might be semantic inconsistency throughout the entire KSGA. I'm looking at subsection F, and it says, if an offense is classified in a grid block below the dispositional line, the presumptive disposition shall be non-imprisonment.
Well, let's look at G. Dispositional departure includes imposing, quote, prison when the presumptive sentence is non-imprisonment, unquote. Or subsection I, a durational departure means a departure sentence which is inconsistent with the presumptive term of non-imprisonment. So we have 3, maybe 4 examples there, the KSGA, appearing to say probation is a sentence. So how do you square that with the language from Carr that you were giving us a few minutes ago, which is like a 2002 opinion?
Yes, Your Honor. To talk about Carr, I think in that case, this court was concerned with upward durational departures. And essentially what this court held is that since probation is an act of grace, it can either be accepted or rejected by a defendant. And I think the holding in Carr would be undermined if probation were itself a sentence, or at least punishment, which is how it was imposed in this case.
Well, whether it's undermined or not, what do you do with the language from the KSGA that I just recited to you?
Your Honor, to the extent there's inconsistency in the KSGA, I guess I would just go back to the definition of a presumptive sentence, which is the sentence provided in a grid block. And the grid block, I think by any reading of the KSGA, does not absolutely control whether something is presumptive prison or presumptive probation. It's the starting place.
Subject to some of the exceptions that you're referring to and Justice Rosen referred to.
Yes, Your Honor. That's the best answer that I can give to this court.
Is there anything in the guidelines that specifies the order of imposition? I mean, prior case law before the guidelines says you impose prison before you order probation. But here, the only way we get to the argument that we have a departure is if you impose probation as your sentence, and by the way, your underlying prison term will be this. Versus, I sentence you to 9 months in prison, give you credit for time served of 12 months, and then I put you on probation. And in that sequence of events, you've already satisfied the first part of the judgment. There's nothing then to probate, to put you on probation from. But on the other side, you have to be revoked before you get the actual credit. If you're imposing a sentence of probation, and if you violate that, then you get 9 months. Is there anything in the guidelines that talks about the order of imposition, or which is the judgment, or
I don't think I have a good answer for that question today, Your Honor. I simply don't know at this time. And I do see that I am out of time. If this court has any further questions, I could entertain those. If not, I'm prepared to conclude my initial argument.
I did have another question. Let's assume that we disagreed with you and we found that this was a presumptive sentence. I think you recite an exception that this court has found, and that's what I call the Warren exception.
Yes, Your Honor. So with jurisdiction, an appellate court always has jurisdiction to consider whether the district court properly understood its authority under sentencing statutes. And in this case, we believe that the district court erred by misunderstanding itself to have the authority to impose probation. And that's based largely on the Carr case, Your Honor.
Let's go back and look at what was going on in Warren and also the case from the Court of Appeals that it cited, Cisneros. Both of those cases involved a defendant asking the court to depart from the presumptive sentence. And in both times, the district court said, I don't have authority to do that. So the case was brought up on appeal, both of them, and the state said, these are presumptive sentences. You cannot appeal these. And the argument was made, well, the district court thought he or she did not have authority, but it's clear from the KSGA that they did. And so this court said, we're going to consider this as an exception to jurisdiction. But what we have under your facts is the flip of that, correct?
That's correct, Your Honor.
You have a judge who says, I have authority to do this. And you're asking us to say, to consider this now as an exception to the facts that were found in Warren and Cisneros, correct?
Yes, Your Honor.
Okay, can you justify for us why we would extend Warren to your facts?
Well, Your Honor, I think that's because you have the same basic problem, which is the district court thought that it was permitted to do something by statute, but was not. You have the same basic problem of statutory misunderstanding affecting a judge's sentencing order. The other thing I would note is that perhaps maybe this could be rephrased as the district court simply did not have authority to do what it did in this case. In other words, it didn't have jurisdiction to do what it did.
Well, you wouldn't have to
Something of
get
that
to
nature.
jurisdiction. It wasn't authorized, so that would fit the definition of an illegal sentence. If you're saying you're not authorized to put someone on probation when there's no remaining term left on their underlying prison, and that's basically what you're saying. When there's no more prison term left, it's all been satisfied, you can't have probation, and if we agree with you, then we could correct that illegal sentence, couldn't we? Because that can be corrected at any time.
I believe that's correct, Your Honor. That would be another way to get to this issue.
But that's not how you've brought your case.
That is not an argument presented in the petition for review, Your Honor. That is correct.
And so if I understand your point earlier in response to my question about why we would apply the Warren exception to the flip of the facts that we have here, do I understand you to say that they both would involve mistakes by the sentencing court on whether he or she could impose a particular sentence? In the one instance, they thought they had no authority, but they did, and in this one, they thought that they did, but they don't.
That's
Is that
correct.
what you're saying? All right, thank you. Any other questions? Thank you, counsel.
Mr. Chief Justice, may it please the court, Daniel Obermeyer on behalf of the state of Kansas. I'll address first the jurisdictional issue, and then I will move on to the merits of this case, Your Honor. The Court of Appeals correctly concluded that it lacked jurisdiction to consider this case because the district court imposed the presumptive sentence through the Kansas sentencing guidelines. If we look at KSA 216804, there is quite clearly, as we've been reading through it, Your Honors, the sentencing guidelines, and these are the guidelines which applied to Mr. Kinder in his sentence with an underlying prison sentence in KDOC custody, which the judge determined to be 9 months, with a presumptive probation. That is the legal sentence which the court imposed, and it's the only sentence which the court could impose under the Kansas sentencing guidelines. If the judge were to do what the defendant asked him to do, which was essentially grant a dispositional departure to time served without probation, that would have been an illegal sentence.
Could he sentence him to probation without having an underlying prison term?
Yes, Your Honor, I believe that he could. And
What happens in that case if the state attempts to revoke the defendant's probation?
in the state's brief, the state cited to the probation revocation statute 223716 subsection C11. In that case, the court or the state delineated differences in subsection C, where it says the dips and the dunks which the district court can impose for violations of probation cannot exceed the total length of the underlying sentence. However, C11 does not have that language referring to the total length of the
Well,
underlying
let's
sentence.
say the state, in this case, there's a probation violation. The state moves to revoke. The court grants the motion, revokes probation. What happens?
Then the defendant would be placed into KDOC custody, and then I imagine almost released immediately for
So
post-release.
just practically speaking,
Well,
what are we dealing with here?
well,
The state desires to have a probationary period for which there's no remedy for a violation.
Well, Your Honor, I think that the probation revocation language, you can impose a 60-day sanction in county jail for violations in the statute, which.
But you can't exceed the amount of time that he's already served, which is his full sentence.
I think, well, but in state's brief, it more clearly delineates that. While other subsections do have that, it cannot exceed the length of the sentence. C11 does not have that language.
So it would be your position that you could impose those sanctions, those short-term sanctions, even if it exceeds the underlying sentence.
Yes, I believe that the legislature contemplated the situation when it included that
Has
provision.
it been tested on double jeopardy grounds or due process grounds that you can serve your maximum sentence and then serve some more, and then serve some more, and then serve some more at the discretion of the judge and the prosecutor?
Well,
Doesn't sound right, does it?
that's Justice Johnson. That's the language which the legislature included. I don't think that it's not a violation for the same offense, though. It is a sanction which can be imposed for the probationary period for the probationary period. And I think that probation serves two purposes: punitive and rehabilitative. So if we're looking at probation as a period for the defendant to show that they're no longer going to reoffend, and it's important that the defendants are placed on probation even if there is no underlying sentence, because as counsel noted, special rules apply, which would make Mr. Kinder and other defendants presumptive prison.
So what,
Excuse me, let me just clarify, the district court did grant credit for time served
Yes, Your Honor.
of almost 5 days short of a year.
Correct.
What was the effect of that? Once he grants credit for time served and the sentence is 9 months, what's the effect of, what does that credit mean? What if it doesn't satisfy the judgment against him, what does it do?
It means that he will not be placed in any lengthy term in KDOC custody. There's still the issue of post-release and whether that comes into play, but the presumptive sentence in this case was probation, so I think from plain reading of the statute, that's exactly what the district court felt had to be imposed by law.
so under the facts of this case, as I understand your position, one of the terms of his probation was to have no contact with the victim who was a dependent adult.
Correct.
Is that right? And if the judge on sentencing said that is a condition, and then the CSO assigned to Mr. Kinder a few weeks later saw such a contact and said, I believe my client is violating the terms of his probation, it's your position that at a maximum, he can then be brought in and put in the county jail for 60 days
I believe that's,
under C11.
yes, Your Honor.
And because C11 does not have the limitation that some of the other subparagraphs were that you referenced, that is perfectly fine, even though he's already done all the time that the judge had required in the first place.
Yes, I believe that's permitted by the statute. And to get to that issue, the court can, I believe that that's what the legislature contemplated again in
Well,
putting.
let me go back to that. You've said twice now that that's what the legislature contemplated.
Yes.
They contemplated that somebody would serve their entire term, then their probation would come after that, and they would be subject to jail time if they violated the terms of their probation. That's how you read C11?
I think that's a reasonable reading of it.
Do we have any evidence to show what they were trying to do when you say that's what they contemplated? Or is that just your view based on your reading of the statute?
That is, I believe, a common sense view based on the reading of the statute, Your Honor. I do not have the legislative history behind that. But again,
So it may be difficult to then say, what was their intent? That they foresaw circumstances like this? Is that right? And if so, what were they trying to preserve or protect or accomplish?
I think that what they would be trying to accomplish is to ensure compliance with probation in a sentence where the defendant might have, in this exact case where the defendant has served all their underlying KDOC sentence, but still they have a term of probation which they're subject to certain terms and conditions, and they need to apply. And I think that that was their way of discouraging flagrant noncompliance with terms of probation. To get back,
Counsel, if I could, before you jump to your next point, an important rule of statutory construction is that we are to construe statutes, if we can, in a manner that renders them constitutional. And if we were to adopt the statutory interpretation that you have proposed, how does that comport with due process? Because we are depriving someone of their liberty for an offense that's proved up at a probation revocation hearing on a preponderance of the evidence. How does that comport with due process?
well, Justice Stiegel, I think I need additional briefing on. I need to do additional briefing on that issue. But even if you decide that that's not a constitutional remedy, probation has an intrinsic, again, rehabilitative and punitive aspect in and of itself, where the defendant has to report, has to comply with the terms of probation.
But if there's no remedy, if the state has no remedy for a violation, then it's a paper tiger in this case. I mean, the defendant actually doesn't have to report because there's no remedy. That's what I'm struggling with.
Well, then, Special Rule 9 in the sentencing guidelines, they're on probation and they commit a new felony. If Mr. Kinder had reoffended during the term of his probate, or let's say the court had granted his request at sentencing, not sentenced him to probation, he goes out, commits the next day. If the judge had followed the sentencing guidelines, he would be Special Rule 9, and he would be presumptive prison from that point. But if he commits another presumptive probation offense, he's just going back on probation.
I'm struggling with sentencings that are happening every day in this state and when finally you get through allocution and sentences imposed in presumptive probation cases, the judge usually says something like, I'm going to suspend this is a grid box such and such, calls for 9 months of imprisonment. I'm going to suspend the imposition of the prison time and place you on 12 months of supervised probation with the following conditions. Here, there's no sentence to suspend. And gets back to some of the questions we've had earlier. That's always the condition that's there, is that there's something to enforce the probation as a consequence if you don't comply. And here there's nothing to do that with. And so I guess my question is that the wrong way to put it? It should have just be, I'm going to place you on probation and not mention anything about an underlying sentence. I don't think that's correct, because I think the defendant has a right to know what's at stake and what the sentence is, and that's what the sentence is.
Well,
Where do we stand with that? This is something that happens all the time. It's how it's done.
Well, Justice Rosen, if Mr. Kinder had been had violated on probation, and let's say his probation had been revoked, then again that would mean that he would be subject to KDOC post-release since his underlying sentence had been served. So that would, I guess, that would be my response to this. And I understand the court's struggling with imposing probation with no underlying sentence. It does seem unusual, but
why wouldn't that fulfill your argument that, oh, we need to have this for rehabilitative or to protect the public or whatever? If there's going to be post-release supervision, why isn't that sufficient as compared to the probation? Because post-release supervision does have some teeth to it. There is some statutory sanctions, even if you're given credit for time served, right?
yes. My response to that would be that a sentence is composed of two parts, the disposition and the duration. If the judge sentences someone without one or the other, then it's an illegal sentence. So we have to start with probation in a presumptive probation case and then get to the point where we're talking about post-release.
We have a whole line of cases, and some of them I think are even after the guidelines came in, that call probation an act of grace. And what I hear you arguing is it's not an act of grace, it's mandatory, and that a defendant cannot refuse to accept that act of grace, but must accept probation even when they don't desire it. Is that so? So we were wrong when we said it's an act of grace. It's a mandatory, non-refutable act of grace.
I think that the most recent cases where you talk about it being an act of grace are where probation is being revoked, or whether there's a dispositional departure to probation. In those cases, it's an act of grace. In this case, it's an act of the legislature, which is mandated upon the courts.
So if the defendant says, I don't want to be supervised by anybody on probation, don't want to run that possibility, just let me do the full sentence, your position is that is not the defendant's choice. That's the judge's obligation under the guidelines?
In certain circumstances, I believe a defendant can surrender their probation, but at sentencing, I don't think, unless the defendant files a motion for dispositional departure to prison, I don't think that that would be a legal sentence at sentencing to just give a defendant prison because they asked for it at sentencing. You have to follow the procedure in that case.
That was not an unusual circumstance. 100 years ago, when I was practicing, have a client say, I don't want probation, let me flatten my time. Tell the judge that, hey, my client accepts the fact that he can't perform, he's not going to be able to perform on probation and wants to get this over with and move on. And so you're saying that's no longer available. The choice of the defendant to refuse the act of grace and simply accept the imprisonment portion of the judgment.
In lots of cases, I think that that's the case. If I can give an example, Senate Bill 123, there's that requires mandatory drug treatment. And it's very hard to get revocations on those cases, Your Honor. So,
but I'm asking you that a defendant no longer can decline probation.
I would say that they can't decline probation any more than they can decline prison, Your Honor. If it's what's mandated, then that's what the court has to follow.
As a practical matter, are they required to sign the conditions of probation?
I believe so, yes.
And if I say, well, Your Honor, my client's already advised me he refuses to sign the conditions of probation, and so let's just start with revocation. And if we disagree with you about you can do 60 days, serial 60 days, even after you flatten your time, if we disagree with you on that, then what's been accomplished here? Because there's nothing that you or the judge can do. Is there?
In terms of imposing new sanctions for violations of that probation, Your Honor? Is that your question?
If he's flattened his time and you can no longer put him in jail, if we disagree with your C11 or whatever,
Yes.
then there's no way to enforce it. And you have interpreted the statutes in a absurd and meaningless manner, haven't we?
Well, to mean that the court cannot impose probation when the sentence is served. Is that what I'm understanding?
Right.
I think I would just go back to the plain language of 804 and say that there's two components to every legal sentence which the court has to follow, and whether or not there's any teeth behind the probation part. As I said, there are other consequences for violation of probation, such as potentially other criminal criminal ramifications for criminal violations on probation. Excuse me. I see that I'm out of time. If I may briefly conclude, unless the court has any other questions.
I did have a clarifying question. In light of what you said earlier, is it your position that if the KSGA mandates probation and the defendant says, I don't want probation, I just want to do my full term, send me to prison for the whole thing, the judge would say, I'm obligated to put you on probation?
I believe so.
Okay.
Yes.
And if the defendant did not like that afternoon, the defendant could go out and reoffend or be in violation of the conditions of probation, and that allows him or her to go to prison.
Yes, Your Honor.
Would you, all right.
I would agree.
But couldn't the judge at that point in time make a finding that the likelihood of success of probation, that you're not a good candidate for probation, and based upon the statements that I'm not going to comply or whatever it is, I want to flatten my time, this is what I want to do, that creates an exception where the judge then can impose the time, doesn't it?
Are we post-sentencing on this?
No, we're just at sentencing.
We're at sentencing and the defendant saying, I'm not going to comply with the terms of probation.
I'm not going to do this. Same with Senate Bill 123. If someone says, I'm not going to go to treatment, I'm not going to do that, there's an exception there. I know it's a tough hurdle to overcome, but there's an exception where you can find that they're not going to be suitable for the program.
Not amenable.
No. That's a finding which the court, I think, would have to make. That can be dealt with in sentencing.
Yeah, and I know these aren't the facts here, but
Okay.
I think that can occur.
I think you were about to ask if you could have about 30 seconds to wrap up.
If I
The
may.
answer would be yes.
Thank you, Your Honor. So, I believe a majority of this court would recognize me saying that there's a certain professor in Topeka who has a famous saying, not to think great thoughts, but simply to read the statute. I would ask this court to read the statute, Kansas Sentencing Guidelines, find that the district court gave the presumptive sentence, and as such, this is not an appealable ruling. And thank you for your time.
Thank you, counsel.
May it please the court. In my view, if the state is correct in stating that after the term of prison has concluded, that a defendant can continue to be punished on probation with 60-day jail sanctions, I think it's difficult to conceive of probation as anything other than having some type of punitive aspect. And if probation did have a type of punitive aspect, I think it would be punishment, and the rationale of Carr, I think, would go away, and the legislature would be exposing itself to a number of Apprendi challenges to the KSGA. And I don't think that that is a result that the legislature wishes or intends in its current construction of statute. So I think that that is an argument not to construe statute as the state requests in this case.
Where does
So-
post-release supervision come into play here?
Your Honor, post-release supervision by statute begins at the completion of a prison sentence. So in my view, post-release started in this case the day after sentencing, regardless of what happens with the probation order, because the prison sentence is complete.
And so by the guidelines of, in effect, what the court was ordering was post-release supervision. It said probation, but the statutes say that it should have been post-release supervision.
Right. I think by statute there should have just been post-release supervision in this case at the conclusion of sentencing.
But logistically, that comes through the parole board and the Department of Corrections, doesn't it, rather than the court?
Well, it may be, yes, that's supervised by the Department of Corrections, and I don't know if it would be the case that Mr. Kinder would have had to have been transported somewhere so that the post-release could be effectuated. But it begins at the completion of a prison sentence.
Was he ever sentenced to prison, though? I mean, it's an interesting question, but does post-release kick in when you're not sentenced to prison? He's just served his time in the county jail. Has he effectively been sentenced to prison, so post-release would kick in?
I think there's an argument there to make that because he was released from jail and never spent a day in prison, that there is no post-release.
Right.
But he was sentenced to 9 months, correct?
Yes, Your Honor.
And got credit for his time in jail. We were talking earlier about C11,
Yes, Your Honor.
and I don't know that you referred specifically to it in your rebuttal remarks, but I took it that's what you're referring to when you basically said you did not think that the legislature meant to have probation be punitive, but more rehabilitative. And if that is correct, what do we do with C11? If you were writing a decision for the court, would you say we cannot consider it, or because it results in an unconstitutional, a problem of unconstitutionality, or what do we do with that?
If this court could...
You know which one I'm referring to?
I don't know
one-
the statutory language.
Okay, I'm sorry. It's the one that the state referred to, and it basically says if you have been convicted of a felony, and then you're on probation, and then you violate the terms of your probation, then one of the sanctions under C11 is you can be put into the county jail for up to 60 days.
Yes, sure. I think...
Is that what you were referring to earlier, or something else?
That is what I was referring to, Your Honor. And I think that really the legislature probably did not include a provision in there explicitly stating that you couldn't do that beyond a defendant's prison sentence because it did not foresee, in my view, unreasonable applications of probation, as were the case in this case, because it presents a number of due process problems if that were actually done in practice. Basically, a defendant would be put in jail for 60 days as a punishment under a probable or preponderance of the evidence standard, which is...
Well, you mentioned Apprendi too, that you've increased the maximum penalty for that crime without submitting the facts to a jury, right?
Yes.
You have judicial fact-finding of a PV that's going to give rise to the 60 days, and that's punishing beyond the statutory maximum for that crime. Was that your Apprendi argument earlier?
That is an Apprendi argument. I think my earlier Apprendi argument was that if this court interpreted statute that way, then probation itself would be punitive. And if probation itself is punitive, every time you move a dispositional departure, you're moving from one punishment to a more severe punishment. And that would call into question a number of KSGA sentencing provisions, which is not a result, I believe, that our legislature wishes or intends.
So do you have an issue with the language in C11 and surrounding provisions that would appear to suggest that under C11, you can keep somebody incarcerated longer than their full prison sentence? Do you have an issue with that? Or you have an issue only with how that would be applied to this case because he had already served his time?
Well, Your Honor, my issue with the actual interpretation of statute that the state makes in its brief is that it's an absurd result and that this court should interpret the statute to avoid that absurd result. I think that if this court did interpret statute the way the state wished, then it would cause a number of peripheral constitutional problems that would come up in other cases, but not directly presented by this case.
All right, thank you.
Don't we have a statute in the probation section that says that you can only serve up to 60 months or the maximum length of your prison sentence?
That's on the graduated sanctions track.
Okay,
There's a
okay.
provision that explicitly says that. And on the 60-day jail sanctions provision, there's no similar statutory provision.
Do you have any further presentation for us?
I do not, Your Honor.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement. Now turn to the third case on this morning's docket. That is case number 117201 in the matter of Alvin R. Lundgren. I had mentioned when the docket was called this morning at 9 o'clock that there would be a recusal on this case, and I would announce our substitute jurist at that time. Justice Beyer is recused, and sitting in her place to my left, this is Judge Catherine Gardner, a judge on the Kansas Court of Appeals. She has read all the material. She'll be fully participating in the oral arguments and then also in the ultimate resolution of the case. As we did yesterday, Judge Gardner, on behalf of the court, I thank you for helping us out today.
You're very welcome. It's an honor.
Thank you. Counsel, one more matter, if I may. When the case was read at 9 o'clock this morning or a little earlier, Mr. Lundgren did not announce his presence. I do not see anybody seated at opposing counsel table, but let me make a general request. Is Alvin R. Lundgren in the courtroom? Very well, counsel, you may proceed.
May it please the court. The Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. As the court is aware, this is an original proceeding in attorney discipline. We had a hearing on October 6, 2016. Mr. Lundgren did appear at that hearing and he did offer testimony. It is my understanding that he advised that he was not intending to appear here yesterday. Our hearing panel found that Mr. Lundgren was admitted in 4 states, California, Utah, Missouri, and Kansas. In 1998, his California license was suspended for his behavior of engaging in the unauthorized practice of law. And then in 2000, the Missouri Supreme Court also disciplined him for the same engaging in the unauthorized practice of law from California. Subsequent to that, there was a complaint that was filed with the Utah Office of Professional Conduct. That complaint resulted in findings that Mr. Lundgren violated 1.15 when he misappropriated client funds, that he provided false information during his admission process, and that he engaged in general misconduct. During that hearing, Mr. Lundgren advocated that he had no history of any attorney discipline. He was disbarred in the state of Utah, and subsequently the state of Missouri disbarred him. While the Utah case was proceeding, he voluntarily surrendered his license to the state of California. And on that form, under the penalty of perjury, he advised California that he was not currently under any kind of attorney disciplinary proceeding, which was false. California did accept his voluntary resignation. He then appealed the Utah disbarment, and the Utah Supreme Court found that during his disciplinary hearing, not only did he admit to converting the complainant's funds, but over a 4-year period, he converted other client funds, and that he used that money for personal use. The Utah court found, based upon his assertions, that he did not have any prior attorney discipline, and they ordered him to be disbarred. To Kansas, the respondent did not self-report any of his disciplinary actions. We learned of the Utah proceeding from the Utah Supreme Court, and then our office uncovered all of the other disciplinary actions. Our hearing panel found that he converted funds, engaged in dishonest conduct, and made false statements during the disciplinary process. The panel also found that he failed to report and he failed to update his address. And as of today, his registered address is still an address that he abandoned several years ago. Service was effectuated by this court based upon the address that he provided during the hearing, and clearly, because he did advise that he wasn't going to appear here, he was aware that this matter had been set. The panel recommended that he be disbarred, and that remains the recommendation.
Counsel, just to add a little more specificity, can you tell us how Mr. Lundgren was advised of the hearing today?
Yes, Your Honor. A court clerk received a call from Mr. Lundgren. This is an email that was sent yesterday at 11:28 a.m. And it says, Mr. Lundgren is scheduled for oral arguments on the disciplinary matter tomorrow, 5/3/17. I received a call from Mr. Lundgren stating that he would not be able to make it to his scheduled oral argument. I took his number and called him back. I called him back and informed him that as he was notified in his letter under Rule 212, E5, his appearance was required. He replied, well, I cannot be there, and I am respectfully notifying the court right now by calling in. My response was, any information that is intended for the court must be submitted in writing. He asked for our fax number, and I gave it to him. And I did not see a fax, and I honestly did not follow up because it was my understanding that this was pretty much a concluded issue. And the fact that he's not here, my concern always is to make sure that they know that they're supposed to be here, and clearly he did.
Any questions of counsel? Any further presentation?
No, Your Honor.
Your recommendation today is to disbar.
Yes.
All right. I see nothing further. Thank you, counsel.
Thank you.
That concludes this case that we will take under advisement, and the court will be in recess until 9 o'clock tomorrow morning.
All right.